Good morning, everyone. Welcome back to Business Law 1. Today we are going to be looking at Chapter 13, which involves form and meaning. So we're continuing our examination of, particular details associated with contract law. So in terms of overall learning objectives, I would like for us to understand which types of contracts must be evidenced in writing. In the body of contract law in the United States under common law, this is referred to as the statute of frauds. So if a contract does fall under this category of statute of frauds, it must be in writing in order for it to be enforceable. If it's not in writing, then it's not going to be enforceable. We're going to talk about what kind of prior effect of like side agreements have on a written contract in this chapter, as well as how a contract is to be interpreted if its meaning is disputed. So that's the overall kind of like big picture of what I hope for us to take away from this chapter today. So in the world of contracts, most people I think understand, the concept of a written agreement. So, like sometimes it's referred to as the four corners of the document. And so that's where you evidence, offer, acceptance, consideration, for a lawful purpose. Parties have capacity to contract and so on. You can have verbal agreements. It's not that verbal agreements are not permitted, because they are. But there are some categories where it has to be in writing in order for it to be enforceable. In a previous textbook, there was an example where the actor Mark Wahlberg and the director Steven Spielberg verbally agree to work on a movie. And so, obviously Spielberg the director, Wahlberg the actor, and so, even though we're talking about potentially millions of dollars of compensation for Wahlberg's, acting performance, the fact that it can be performed under a year, the fact that it's a service-based thing, that would be acceptable, even though, you think of a complex, kind of arrangement like that, you might want to memorialize it to writing. But it could be verbal in that particular situation. Otherwise, if we're looking at contracts that must be in writing, and I'm going to go through the criteria in the next slide, then it has to be written, if that's what the law requires under this idea of statute of frauds. And so the idea with statute of frauds is that there are some agreements that are so important, and we want to make sure that we get it correct in terms of the formalities. That's why we require them to be in writing. The merger doctrine that I have at the bottom of this slide, essentially what this is in reference to is that sometimes you have like parts of a contract that you might have an offer here, you might have an acceptance in a different document, you might have evidence of consideration and even a third document. And so, like pieces of a puzzle, you can merge them together to get the overall picture that there is an otherwise complete contract. So, ideally, you'd like that contract to be in a single document, but it is possible to kind of piece it together to show that, okay, there was the intent, there was the acceptance, there was the consideration that flowed back and forth. So that's the merger doctrine. Okay, so statute of frauds, these are the types of contracts that, if you're going to enter into them, they must be in writing. If they're not in writing, then they're not going to be enforceable. And if you go to, let's say compel the other party to perform as promised, and you go into a courtroom setting, if it's one of these types of contracts and you cannot produce a writing, then the case just gets dismissed. So if the agreement cannot be performed within a year after the contract is made, must be in writing. Anytime that you purchase real property, so we're talking about land, house, building, structure, whatever, but land in particular, that has to be evidenced in writing. If you're going to be answering for the debt of someone else, so let's say you have a sibling, a child, a parent, a friend, and you want to assume their debt for some reason, credit card, whatever, it doesn't matter the type of debt. Obviously the creditor is going to take your money, but what they really would like to do is to bind or obligate you, almost like a co-signer after the fact, and so they'll want you to sign an actual document, and that's up to you, if you want to be able to do that or not. If you're an executor of an estate, and we get into this in more detail in business law too, but that's the person who kind of administers a will. Sometimes they will pay claims out against an estate for like minor, like let's say the last utility bill, or last kind of like if it's a relatively small obligation that they pay, they certainly are entitled to recover those funds that they advance, but that does need to be specified in writing. Any type of promise made in consideration of marriage, so we're referring there to prenuptial agreements, that has to be in writing. No such thing as a verbal prenup. Sale of goods, if right now under the Uniform Commercial Code, if it's $500 or more, then these transactions must be in writing. The UCC is in a process of raising that to $5,000, but that hasn't been fully adopted yet. So if a contract for, like, let's say a sale of goods or services, if it's going to be more than $500, has to be in writing. And then there's just a collection of like local statutes that are required, and that's based on state or local law. A common example there would be like an exclusive listing agreement by a real estate broker, that they're going to have the exclusive rights to be able to sell a particular parcel of land. Anyway, as I mentioned, the effect of non-compliance here is that the contract is not going to be enforceable. So, if you have a piece of property, like let's say a house that you're selling, and I come look at it and I'm like, hey, this is great, and I'll buy it. And so we agree on a price. Obviously, we know the parcel, land, the house that we agree upon, and we may say closing in 90 days, and we shake hands on it. Well, okay, we're on our way, but I mean, that's not a binding contract yet. It has to be committed to writing in order for that to be enforceable. When it comes to signatures, usually, the law has been fairly kind of like expansive regarding the evidence that someone indicates in a written document that they are agreeing to whatever the terms are, and how that writing or that signature is evidence of that person. And so, whether it's a very elaborate signature, you see that second one from the left, that was at the artist Prince when he was alive. For a while, he kind of gave up his name as Prince, and he kind of had this, I don't know what that image is, like a glyph or something. And that was how he evidenced in writing when he would enter into contracts. The law has been amended also over time to reflect changes in technology. So we all probably have had instances where we'll e-sign a document, and so even though it's not actually on a physical piece of paper, it's digital, but that still is a binding signature at that point. Another topic that comes up in this chapter is what's called parole evidence rule, and normally this rule prohibits the introduction at trial of any verbal testimony that kind of counters what is memorialized in the actual written contract. And as long as the contract is otherwise complete, there's really no need to entertain outside testimony. So, let's say that, again, you and I enter into this contract for me to buy your house. And so we have a written agreement, so we know, we've learned, it's like, okay, it can't be verbal. And so, we write it all out. It's very clear, the price, it's very clear when closing is, and maybe other particular terms, maybe the deposit and so on. And so, we're going into closing, and let's say there's a dispute that arises, and so we end up in court. And I may say, well, Your Honor, sure, we have this contract, but, when we shook hands initially, the verbal aspect of this, that was a prelude to the written agreement, we talked about, let's say, A, B, and C, maybe some specific terms. A lot of times a judge is going to say, I don't need to hear this outside testimony because the contract as written is complete. And so, unless there's an ambiguity, unless there's, some other issue that has arisen, they don't really want to hear this outside stuff. And part of it is just judicial economy. you know, if you have this complete agreement, why do we need to kind of spend time talking about what led to the agreement? Unless there is a basis for that, because there's something lacking in the contract. And I think also the other kind of rationale for parole evidence rule is that, you know, if it was really that big of a deal in terms of like the negotiation phase, it would have been put in the contract. And the fact that it's not in the contract, it must not have been that big of a deal. So that's really the idea with parole evidence, is that if the contract is otherwise complete, you've got offer, acceptance, consideration, all the terms are there, it's fairly clear, not ambiguous, then we're not going to like open up like a, you know, this whole verbal testimony about things that happened leading up to the written agreement. There's not really a need to do that. So so other situations that can arise where you know, you may want to introduce evidence outside of the contract. So again, if the written contract is somehow incomplete or maybe it's ambiguous, okay, well, maybe we might need to pull in some outside testimony at that point. If maybe I'm alleging that there was some sort of fraud or duress or mistake that kind of induced me into, you know, signing the contract, well, that might be relevant. If the contract, I think, has been modified, you know, so maybe, you know, someone photoshopped it, or there was some sort of, changes in the terms that I didn't agree to. If maybe the contract in part includes some element of illegality, or if I'm just trying to say that some aspect of it is non-binding. So if I can allege any of those things successfully, then that's going to permit me in a courtroom setting to be able to say, okay, let's open this up now to all this verbal testimony, maybe witnesses, maybe statements that I made. I might call you to the stand as a defendant, and kind of just say, okay, what did we discuss, in terms of the what led through the negotiations up to the point where we had a written agreement. But normally, under the parole evidence rule, we don't need to do that, because the agreement is otherwise complete at that point. So anyway, in terms of the big things in this chapter, really the two big things is the parole evidence rule and then the statute of frauds. Just remember, with statute of frauds, that there are certain categories of contracts that they have to be in writing in order for them to be enforceable, and if they're not written, then it's a very strong likelihood that those disputes, if they go into court, will just get dismissed. So maybe if you could allege some other theory, like promissory estoppel, detrimental reliance, you have to have some other theory maybe that you could kind of pull that in. But a lot of times, if it was supposed to be in writing and it's not, then we're just going to say that that the case is dismissed at that point. So anyway, that's really this chapter. Those were the big things that I wanted us to get out of this chapter. So as you have questions, please feel free to message me. But otherwise, have a good, safe, and productive week. And I'll be chatting with you all online real soon. Thank you so much. Bye-bye.